Welcome and good morning, everyone. Welcome to the CYCJ webinar on disclosure. It's very pleased to have you all join us this morning for a very topical issue that we're going to get informed more about over the next hour or so. So it's my pleasure. I'm Fiona Dyer, Director at CYCJ, and it's my pleasure to chair the webinar this morning. First of all, today we're going to hear from Claire Lightowler, who works for Clan Child Law, which is a children's charity which uses law to advance children's rights. Claire is a trainee solicitor there, but many of you will recognise her as the previous director at CYCJ. We're also joined by two colleagues from Disclosure Scotland. Stuart Rafferty is a customer engagement manager and has worked with disclosure in his role for over 10 years, but been a civil servant for over 43 years now, Stuart. He's joined by his colleague David Smith, who manages the team in Disclosure Scotland that deals with applications to review the information. And I'm being told by Stuart that David's here to help with all the technical questions you may have. So welcome today. We're going to hear from Claire first, who's also going to include the voice of lived experience within her presentation. Then we'll hand over to Stuart and David. Please do add any questions you have into the chat, and we'll have time at the end to answer hopefully all your questions, or as many as we can. So without further ado, I'll just hand you over to Claire. Thank you.
Morning, everyone. It's really exciting to be back talking about disclosure. Honestly, one of my favourite subjects. I hope it will be yours at the end of this. So I'm just going to share some slides here, which will talk us through. I've tried to use a lot of diagrams to explain what is potentially quite a complicated system. So we're talking here about the disclosure of childhood criminal convictions. I'll go in to talk about exactly what that kind of means. That's my email. If you do have questions, please feel free to after today contact me. But also, Fiona mentioned I work for Clan Child Law. Clan Child Law is kind of unique in Scotland in that we provide legal representation only for children and young people, so for nobody else. And we have a helpline that explains what the law is. So if you have questions about disclosure or other issues in terms of what the law says, then please do feel free to call that number. And we can. That's also the way in which we identify if there's an issue going on where a child or young person really does need a lawyer. And obviously sometimes we can help with that, but we can also signpost to other lawyers that can potentially help. So it's a free service. So I just wanted to flag that up front. So we're talking about disclosure. So first of all, what does this disclosure mean? Here we're talking about what would come up on a disclosure check when you're applying either for employment or college places or other opportunities. But when you're doing a disclosure check, there are other circumstances in which things come up where you've had a childhood criminal conviction. So applying to go abroad, for instance, there are other things. Not really going to talk about that today, but I didn't want to miss an opportunity to just flag up. There are several implications of having childhood criminal convictions. So it's really important to just be aware of that when you're supporting, and I know many of you do, when you're supporting children and young people to understand some of the implications of that. And what we're going to talk about today is what will come up on a disclosure check. And normally that's exactly the same as what you would need to disclose yourself. There are certain circumstances when you do need to self-disclose information, but that's not things that wouldn't come up on a disclosure check. So you can use the same information for that context. I see people are asking about the slides and things. All this information is going to be made available. I've put quite a lot of detail and links in the slides deliberately so you can go in and use it and check things, and some things we're not going to get time to really dig into, but I put links in so hopefully you can then pick that up if you need to do that. So that's what's disclosure, and then what's childhood criminal convictions mean. And here, when we're talking about a child, what we mean is someone that is under the age of 18 on the date of conviction. So that can be a conviction by court or a conviction in the children's hearing system. So if you accept an offence at a children's hearing, that when you accept it, that's the date of conviction. If it's then established at court, sometimes it remains in the children's hearing system, but it goes to the court, for a proof where there's dispute over whether something's happened. And the date that's established at court that something happened is the date of conviction. So even that then immediately is a little bit complicated. And there's something for practitioners in particular to be really conscious of here, that if someone is close to 18, or perhaps not even close, but given court delays and things, it's that they're likely to be over the age of 18 at the date of conviction, then that could have significant implications for them, whether they're a child or an adult at that point. So it's something to be aware of and be thinking about as you're supporting them to think about all the implications involved. And obviously, I would say this, but this is a key point where it might be beneficial for them to get legal representation, because they are having to weigh up quite a lot of different factors about whether they plead guilty, whether they accept an offence or not. And just to flag, obviously, I think it almost goes without saying, that's not compliant with UNCRC, which makes it very clear in their general comments that it should be the date of the offence. So if you're a child when you commit the offence, you should be treated as a child in terms of disclosure and other implications of that. But anyway, that's where we are. So when I'm talking about a child here, I'm meaning a child at the date of conviction. Those that were children when they committed an offence but are now adults at the date of conviction, it doesn't apply to them. So what happened on the 1st of April is various elements of the Disclosure Scotland Act 2020 were brought into force. Obviously, that's quite a significant length of time since that act was passed, these 5 years. But some things had come in before, but really some of the fundamental changes in that act are now in force. And I'm going to keep going back to these and conclude on these points in terms of what are the implications for practice. But I just want to get you thinking about some of this before you'll understand all of the context of it. So I've alluded to this one already, and we'll keep coming back to this. It now matters even more if you're a child or if you're an adult. There's going to be more risk-specific decision-making going on about childhood criminal convictions. That's great because it means things won't be disclosed that really don't need to, because the risk doesn't require it. But it means there's more uncertainty. It's not going to be clear to a child that something that they're doing at a certain age will definitely come up. It's not going to be like that anymore. Something can come up on a disclosure check. It's not that it will come up. Whilst that's welcome for those reasons, it does create a bit of uncertainty and lack of clarity for children. From now on, the offence type is really the thing that's to focus on. That's going to matter most in terms of the long-term implications of childhood criminal convictions. I'll explain what this means, but is it on list A or list B is going to be a key thing to be thinking about and focusing on. And the other side of that is it now matters less for disclosure purposes whether something's dealt with by the court or the children's hearing system. It matters a whole lot for lots of other reasons, but for disclosure, that is no longer as significant as it was. And for some people, though, particularly, here that this means those with criminal convictions that are on list A or list B. In particular, the timescales for the disclosure process are going to be longer. So that's another thing for them to be thinking about, and for you to be supporting them with, really understanding that. And they have some choices along this journey of disclosure, and helping them understand what the timescales can mean in terms of then job opportunities going, employers not waiting, and how it might be helpful to have conversations with employers at an early stage about things that might come up on disclosure. So we thought it'd be really helpful before we get into the detail of the system, to really explore why this matters and what the lived experience of the disclosure system is and feels like. So I'm going to play you a clip. Please shout if you can't hear this on the chat, I mean.
Thank you for coming today. I am going to share a little bit about my experience with the Disclosure Scotland prior to the new Act coming in place, and hopefully what it means for me and other people that have had justice experience and are trying to get into the social care workforce. I had a substantial period of time involved with the justice system when I was younger, and as I got older and evolved and matured, I stepped out of that realm and started pursuing a job in social care. And it wasn't something that happened overnight. I gradually volunteered and built up experience before I went to apply for a PVG. And the process was quite traumatic, actually, you know, especially for somebody that had put so much time and effort into changing their behaviours and their thinking, and really passionate about making a change and helping people that had been in the same situation as them. And the initial process took about 7 months for the disclosure to come. And when it did come, it came followed by a letter telling me that I was going to get placed on the register to be banned because of my previous convictions. And I had no experience in what the process was and what I had to do. I was just following a letter that was sent to me. And luckily enough, I had quite a good support network, and I could get references to enable me to not get put on the register. And that was the start of it, you know. And I went into work, and eventually it caught up with me again. And more recently, last year, I had already been working in the health and social care sector for 4 years, quite vastly as well. You know, like I'd covered quite a lot of different areas that you would need a PVG for. And I went to apply for a job, and I got the job. I disclosed my record during the interview, which I always do because I just think it's really important to be transparent and honest from the start. And they told me that it wouldn't be an issue, that we would discuss it when it came. And it came, and I had already signed the contract. And unfortunately, they phoned me up to question me about my PVG, and then sent me an email to say that unfortunately they were retracting the job. And this is taken into consideration. This is like a 9-year period since like offending, and it happened very shortly again after with another job who also told me that I had the job, and then they retracted it again because of my PVG. And I think it's like really important for me to say, like, I'm not saying that I don't deserve, there needs to be a safeguarding process, and there needs to be quite a rigid process to make sure people are capable of working in that environment. But I think that it's really difficult. It could be a setback for a lot of people. Like, I'm very strong-minded, and I'm able to talk about these kind of processes. But for people that are newly wanting to get into the sector and maybe not as resilient as what I possibly could be, it could be a real setback. And what's the most frustrating thing is, like, I'm a university student studying a course where you need to be PVG'd, and I have been doing that course. This is on my way to go into my 4th year. And that in itself speaks volumes. I feel that if you are in an environment where you've been accepted into work, and not in a non-egotistical way, quite a good worker, you know, very, very driven by procedures and policies and everything being right. And it's just really frustrating. And I think that right now I've actually got a live PVG. I'm waiting for it to come back with the new process. And I've been really eager to see what convictions are taken away from my PVG, not because I don't want people to see that I have a past. It's more that a lot of my convictions, a massive proportion of my convictions were from when I was under 21, and I'm in my early 30s now. And I think it's a really good direction for Scotland to be moving in, especially with the new legislation that's coming in. Of me and many other people that I know have worked very, very hard to get to where we are, and it's quite traumatic when you're faced with, when you think that you think you've created a new person and done a lot of work on yourself, and then you're constantly reminded that actually, in fact, your past is still there, and no, we're not giving you a job. I think it's really interesting to see where this will go and how it will shape out. And you know, I like I said, I'm waiting for the disclosure, the new disclosure process to happen. I've got one live just now. Has took a little bit longer. Just going to say that. It's been 4 weeks. Where are you? But it's also a new process, so I understand. And yeah.
Yeah, I think that really helps to articulate what this means for real people. You know, there's a danger of getting lost in the technicalities of some of this as we talk about it, but this affects real people and has implications for their lives. So beautifully put, and some challenges and questions for us all as a sector about how we're dealing with things. And we'll hear from Disclosure Scotland in particular, who will help for us to understand where they're at with some of this process, which will be great. Okay, so moving on. Just to say, what I'm going to talk about is currently in that briefing paper. There's a link. Some of you might want to follow it as we go. There's some diagrams and things which might be easier to see by having that open. It should be clear enough, but I'm just flagging that now. I am going to update this paper. The paper was based like before April the 1st, so it's explaining the disclosure system that was and the one that was coming in, and I'm just going to take away what was now, so it's a little bit clearer. So I'll be updating that, and we've got some new information about some of that too. So watch out for that if it would be helpful to you. And just to flag, I know many of you know the children's hearing system, but some may not. So I mentioned that childhood criminal convictions include where there's offence grounds at a children's hearing, and they're either accepted, admitted or established through the children's hearing system. And I just wanted to just give a little bit of context to that for those of you who don't know about that. I know many of you do, so apologies, bear with me. But just to highlight that this is the J ground. So that's one of the grounds where a children's hearing can be called. It's the only ground where the criminal standard of evidence applies for obvious reasons around disclosure. So it needs to be beyond reasonable doubt, where that's tested in court. The disposal by the children's hearing is not considered any differently to a child referred to on care and protection grounds. So the same things can happen. And there are these two ways in which a conviction is recorded. This either a young person admits the offence, or it's then established, it goes to the court to be established and comes back to the hearing for disposal. And that process, there's very strict time lines around that process when it does go to court for proof and then comes back to the hearing that don't necessarily apply to other court processes. Obviously, this ground is only available to those over the age of criminal responsibility, so 12. And then more serious offences are jointly reported to the Crown Office and Procurator Fiscal Service and SCRA, the Children's Reporters Administration. And there's dialogue between those two agencies about whether it goes to court or the Children's Hearing System, and the Crown Office decide if they should prosecute and take responsibility or not. So it really is them that's the key decision maker in that process, but there's dialogue between the two. So just to explain that as a bit of context, and then please don't be scared by the diagram. We will talk this through, but this is the attempt really to explain the entirety of the disclosure system in one slide. And I've been trying to understand this for years and years, and still I'm trying to understand it. It is really, really very complicated. And I think one of the things that's really difficult about the system is you need to see and understand the whole system but you also need to then dig into the detail to understand how it applies. And it's quite hard to think about the whole thing while holding the detail. And this diagram is really, and it's in that paper I mentioned, and it's really to try and help explain that so you can see the whole thing, and then there's links to different elements so you can dig into those details and have a look at the specifics and apply them to a young person that you've got in front of you. So I'm going to talk through and spend quite a bit of time now talking through this slide and what it means. So you'll see, first of all, you've got these coloured boxes at the top, level 1, level 2 with BARD, and level 2 with PVG, protected vulnerable groups. So they're the different levels of disclosure. So you've got different levels of disclosure, like a lower level is level 1 and a higher level is level 2. And then there's different variants of that. And what that means is at those different levels, different information types come into the consideration of the disclosure process. And what you've got at the bottom then, these white boxes, are those different types of information. And basically everything on the left of the red line, hopefully you'll see the red lines coming down respective to the different disclosure levels. Everything to the left of those lines comes into play depending on the level of disclosure. So if you think about then level 1 disclosure, you'll see what comes into play, what's to the left of that red line are unspent convictions and what we commonly known as the sex offender register information. So I've just used that language there. And then when you get to a level 2 with PVG, so that's the purple box, you've got all of these things here, all of these things which are to the left of that red line. So they all come into play on a disclosure check. So if you can get that in your head, first of all, I think that's the really key fundamental thing, that different levels, different information types. And so some things are not going to be relevant. And this is, I think, often a key thing supporting children and young people and adults to understand this. There are things that definitely won't come up because they're not an information type that's going to come up. People also don't know that. There's quite a lot of focus on what will, but often we can give some reassurance because it absolutely won't. But not knowing this and understanding this system means people are fearful of doing that. And obviously it is quite complicated. So if you don't know and you can't figure it out, then Disclosure Scotland can help, Clan Child Law can help, CYCJ can help. Please don't feel get yourself in a position where you feel you have to answer information you don't know. So hopefully it's useful information for you to know, but if it gets beyond your competence and ability to answer those questions for children and young people, then obviously don't feel that you should be doing that. So just going to talk through the different information types that come in under these different levels. So level 1, that would be for most jobs. So I will talk about the other jobs that don't, but most jobs so that don't involve direct contact with children or vulnerable adults, protected adults, and aren't on one of the lists for these other roles. I will go on and explain a little bit about how you figure that out. But level 1, so if you wanted to be a lorry driver, for instance, now a child knowing that they want to be a lorry driver is another issue. So supporting them to understand the implications is already challenging. But if we have someone who, as they become an adult, wants to be a lorry driver, then it will be a level 1 disclosure check. And what comes into play at that stage then are firstly unspent convictions. So these are convictions that are that are not spent. So things that convictions that need to be disclosed is basically what that means. Now, everything that's dealt with by the children's hearing system is automatically a spent conviction. So what that means right off is for a level 1 disclosure, anything that's dealt with by the children's hearing system will not come up on a level 1, a lower level disclosure check. What's happened after the 1st of April is that's the same now for nearly all court convictions if you are under 18 on the date of conviction. Almost all of court convictions won't come up on a level 1 disclosure either. There are 2 exceptions to that, and that's where someone is sentenced to custody for more than 4 years, or where someone's sentenced to custody for a sexual offence and there's a custodial sentence of more than 1 year. But other than that, all the convictions that happened before someone was 18 on that date of conviction are unspent. Are spent, so they won't come up. It's only unspent convictions that come up. So that's the first information category. The second is then sex offender register, and that's when a court decides there's a significant sexual element to offending. So it's a process that happens, it's a court decision where they think someone needs to be subject to, they're called notification requirements, so a kind of monitoring process and to be put on this register. So that's what that means. So it needs to be a court process that has done that. And there's a little bit of information about there's different notification periods for different sentences and so on, but that's the route in which that happens. So they're the only 2 information types that would come up for a level 1 disclosure. Again, that's for most jobs, for most people, where it doesn't apply to these specific rules, or where it doesn't involve protected work with protected adults or children. I'm going to go on to the next slide and come back just to explain a little bit more about how you work out about the rules. So again, I'm not going to go through all of this, but I wanted to put the slide so you can go away and think about it and work it out. So as I said, level 1 applies to most jobs. Level 2 and level 2 barred applies to very specific rules, and there's a link there to see the list of rules. So solicitors, accountants, when you're applying for a gambling licence, if you work for SCRA, the Scottish Children's Reporters Administration, a range of very specific things, so you can check the list whether that applies. And for the biggest volume of children and young people and adults thinking about disclosure, it's really level 2 with PVG that's likely to be the most common concern. And level 2 with PVG is for regulated work, where jobs include one of these things. So jobs with a caring responsibility, if you're acting for as a foster carer, if you're teaching or supervising children, providing personal services, or working directly with children or protected adults. And this activity needs to be part of the normal part of their role, and the contact with children or protected adults is not incidental. It also applies to those in positions of responsibility for organisations providing services and support for children or protected adults. But that's how you go and figure that out. And I will now skip back. So let's then think about someone who is wanting to work in social care, or they're wanting to coach children's sports. And in that case, they would need a level 2 with PVG, with protected vulnerable groups, check. And then all of these information categories come in. So the unspent convictions we've talked about, the sex offender register information, and now you have the next category coming in as well, which is relevant spent convictions. So these are convictions that are spent, so they're not going to come up on a level 1 check, because that's only unspent things. These are convictions that are spent, but they're deemed relevant. And that means, what relevancy means is they should be disclosed. So this is where it's the offence type that really matters and to be paying attention to, because certain offences can be disclosed for different periods. So there's 2 lists. There's list A, and these are offences that can always be disclosed. And that includes rape, murder, willful fire raising, assault to severe injury, disclosing intimate photographs, and a range of other things. There's a link, because it's a massive list actually of all the different offence types. So understanding that is really important. So that's list A, they're offences that can always be disclosed. So for the rest of your life, if you wanted to work in social care and you'd committed one of these offences when you were under 18 for the date of conviction, then it can always be disclosed. List B relate to convictions that can be disclosed for a set time period, and that time period is 5 years and 6 months. And this includes offences like assault, breach of the peace, robbery, and again, there's a full list that I've linked to there. And you'll notice I've used the word can, not will. So the offences can always be disclosed or can be disclosed for 5 years and 6 months. And that decision about whether it should be disclosed is taken by Disclosure Scotland. This is the other new element of the system. And they decided on whether it should, whether the information is relevant to the specific opportunity that someone is being sought, and whether it should then be disclosed in that circumstance. So they're the two factors. So they're really thinking about the specific opportunity. So they will be thinking about this differently potentially each time you apply for a different job, because those factors are potentially a little bit different. So that's where there's more discretion in the system, but potentially, as you can imagine, implications for timescales. David and Stuart are going to talk about this review process, so I won't go into it in depth, but there will be opportunities to make representations and to provide information and context to inform that decision-making process, which is going to be really important. So that's the relevant spent convictions. Just to say here then, if an offence is not on either list A or list B, then it will not come up in terms of a conviction. So for instance, shoplifting is not on either list A or list B, so it's not a relevant spent conviction. So it's a type of conviction that will not come up on a level 2 with PVG check. So hopefully that's clear. I am conscious it's dense and you've no opportunities to really ask questions as we go. So hopefully you're keeping going with it. And obviously we can pick up questions at the end if anything's not clear. The next information category that come in are unspent cautions and alternatives to prosecution. Now, for those under 18, all cautions are immediately spent. That means they're not unspent, if you see what I mean. The language is a bit complicated, but they're not unspent, so they're not going to come up under that category. And then there are a range of things that are alternatives to prosecution, recorded police warnings, restorative justice warnings, all kinds of different things. And they're spent at the point of disposal. So as soon as they're issued, then they're spent. And there's other things, other alternatives to prosecution, like fiscal fines, diversion from prosecution, and they're spent after 3 months. So for most children and young people, they're not going to have, and adults, they're not going to have a massive implication for them, because most things are going to be spent after like 3 months, or at the point of disposal, or immediately. So that's something to be aware of, and it will have implications for some people, but for most people who have childhood criminal convictions, it's not going to come up. I'm not sure, sorry, I just see the questions. It's 3 months from completion. I can't remember off the top of my head if it is 3 months after completion or 3 months at the point of disposal. I can't remember. The information will be there. Maybe Stuart and David can answer that question. I think it must be on completion, but I'm not sure. So we will look into that for you. The next category that can come up is other relevant information. This is information that's held by the police, and they hold lots of information, but it's information that they decide is relevant. And that means, again, that it should be shared in essence. And there's a couple of factors that the Chief Constable needs to consider in deciding that information should come up, should be used in the disclosure process. And that's that they reasonably believe it to be relevant for the purpose of disclosure, and that they consider they ought to be disclosed. So there's factors that are not necessarily that helpful in helping you figure out what will come up on a disclosure check. There is criteria that they use, relevancy, accuracy, and so on. And the types of information that might come up are pending cases, firearms information, and really primarily police intelligence. And it's particularly about where the known associates that might use an opportunity to exploit a role or opportunity that someone might gain. But it can be very difficult for children and young people because they don't know what the police hold in terms of information, and they don't know what they will then decide is relevant for disclosure purposes. The next information type are prescribed civil court orders, and there's a range of these, things like sexual harm orders, foreign travel orders, and there's slightly different lists, slightly different civil orders that will be considered for whether you're applying for a disclosure with PVG or non-PVG. So again, it would only come up on a level 2 check, but there's slightly different ones, whether it's a non-PVG or a PVG, and they're linked to below. There's quite a lengthy list of different civil court orders. And then there's barred lists. There's a list. You can be barred from working with children, and you can be barred from working with protected adults. There's sort of two lists. If you've got some convictions, there's an automatic bar that's put on, so you can't work with one group or both groups, depending on what that is. So there's information linked to there about what those are. But you can also be on that list after following an investigation from Disclosure Scotland as well. It's not just about convictions. And then the final thing you'll be glad to know, it comes up, it's continuous monitoring. So the thing that really distinguishes the PVG scheme from the level 2 with barred lists and the level 2 is the continuous monitoring element. So it's not just previous convictions, it's live information is monitored and will then come up and can be flagged. And organisations which are carrying out a PVG are notified of things if you're on a PVG scheme. So that's, in a nutshell, the kind of disclosure system in a diagram form, and there are links, and it does get complicated if you're thinking about a specific offence, specific disposal lengths. Yeah, there's a lot of things that I don't think anyone can answer, or certainly I can't answer off the top of my head without going away and checking, but hopefully this gives you the tool to understand it and to look at those links yourself, or at least ask the right questions to then ask for support from someone to help you answer that. So I've talked about how you figure that out, which disclosure level applies, and I've put that information so you can check that. And then I wanted to go back to the real world. So, right, okay, what does all this mean for children and young people and adults who have childhood criminal convictions? So scenario 1, we've got a young man, Kyle, who didn't have all the information available to him. So he didn't understand a children's hearing. He didn't understand the consequences of accepting an offence ground in relation to willful fire raising. So he accepted that offence ground. He just wanted it all to go away. And he did that rather than explain, actually, it wasn't him that did it. It was his friend. But he now wants to be a youth worker. And so this offence can always be disclosed. And then scenario 2, Kyle this time has an assault and a breach of the peace at age 14. And they were actually a consequence of Kyle being criminally exploited by adults around him, forcing him to hold drugs for them. That led to an attack. Kyle doesn't have an opportunity to explain that context when accepting the offence grounds. At a children's hearing, when you accept or deny offence grounds, you just accept or deny it. You're not given at that point an opportunity to explain that context. He doesn't have legal representation to fully explore the evidence and the potential defences to that offence. So consequently, Kyle has offences on his records that should not be labelled as offences, or at least there would have been a defence for. So an argument to be made for why they shouldn't be actually recorded as offences in the first place. So just to give you a bit of an idea, I'm sure you've got loads of scenarios of your own about what this kind of means and kind of looks like. Just to flag, the fact that children can accept offence grounds that are herein without legal representation, and this can have these consequences for them for potentially life, depending on the offence, but like willful fire raising, for instance, that can always be disclosed, we think is a breach of UNCRC and is something that we are actively considering and thinking about what we do around that. I'm talking to the children's hearing system as well around just to flag that. And I've said already that it's different for adults. So just very quickly, you've got two 17-year-olds accused of breach of the peace. One child's dealt with by the children's hearing system. It's all dealt with quite quickly. So they're still 17 at the date of conviction. One child is dealt through with the court system. It takes a year for the matter to come to court, by which time they're 18 at that date of conviction when they're found guilty. So if they want to work with children, and so would need a PVG check, level 2 PVG, then child A, the breach of the peace, can appear on their disclosure for 5 years, 6 months. Child B, the breach of the peace will appear on child B's disclosure for 11 years, unless they ask for it to be reviewed, which we'll get into. So yeah, quite a significant difference then in terms of those timescales and what that kind of implication can mean. Not going to go into this slide, but I just thought I'd add it for those who really want to know a bit more about the system for adults, which is, it could be a whole, it should be a whole webinar in itself, and it really depends on different disposal and all kinds of complicated different things, but that information's there for you if you're interested in it. And then just to return to the implications for practice. So I've said these already, but just to hammer it home. So it now really matters if, and it always did, but it matters perhaps even more if you're a child on that date of conviction, and just the factors that as a child, someone is having to weigh up about things that might delay something, and then the implications. It's a lot for them to be thinking about if they are to make decisions about whether they want to plead guilty or not, and be fully informed about all the implications. There's going to be more risk-specific decision making, but more uncertainty. Really important to be conscious when you're thinking and supporting people with the implications, to be aware of what's on list A and list B. So when you have a young person in front of you, have a check-in, and you know the offence, check-in is that one that is on list A and list B, so you can support them with the implications. And the timescales of this are going to be significant for children and young people. So then just finally, I'm going to talk through some of the supports and some of the things you can do. There are different ways to support children and young people with disclosure. So before they're accepting offence grounds, I've said already about supporting them to access information and legal advice about denying the grounds. Is there enough evidence? Is there a defence? Is the offence exactly what it seems? So that's obviously really important. Is it an offence that's going to appear on list A and list B? And then provide information as a consequence of that. And think about the other implications. So I mentioned at the start other things like travel. There's some really helpful information from Unlock about different places. So it depends where you're going. Different countries have different systems of what they look into and how they think about it. Again, it is really complicated, but I am conscious that for some people, the travel issue will be more important to them than actually the disclosure for employment or courses or what have you, certainly at some stages in their life. So being aware of that is potentially really important. You can also support children and young people to understand what's on their record. I'm really big cautions about this because you can find information out, but it can be quite alarming if you don't understand what would come up on a disclosure. So it needs real care. But I know a lot of children and young people and adults don't actually know what the offence was, what they were convicted of. So figuring out what's going to come up is a real challenge for them. So it is something that you can think about doing and supporting them with, but they do need a lot of support around this. And there's various ways you can do this, but the key thing is you submit a subject access request to Police Scotland. There's a very easy online form, and you have two options. You can tick everything that's on your criminal record, so that's offences. That includes, though, then everything, so offences that wouldn't appear on any disclosure or on a higher level disclosure that would only come up on a lower level disclosure. So understanding what that information means is so important. Otherwise, you're potentially going to put young people off applying for jobs where something wouldn't come up anyway. So, but anyway, you can tick that and get that information. And this is where there's also an option to tick for the other information that the police hold. So this is the information the police then use to determine whether something is other relevant information and should be then relevant for disclosure. So you can submit that, and then when you have that information about the specific offences and the dates of conviction, you can establish what's going to appear on those different levels of disclosure. You won't know if the information held by the police will be disclosed or not, but you can figure out the other stuff. And Disclosure Scotland have a helpline that can help you figure this out and provide information and support about what's on someone's record. So that's a really key resource. And then there's a couple of others there. There's a PVG checker to see which rules would require a PVG. And I mentioned clanshire law already. So that's it from me. So thank you for listening. I know it's quite a lot.
Thank you, Claire. I think that was just really clear. It's obviously a really detailed and quite a difficult system to understand if you're not immersed in it. So thank you so much. Stephen, while you're just getting your slides up, Claire, there is one question. I don't know if you can answer that by Julianne there. What about EEI? Is that the same as diversion from prosecution? Is it 3 months if a child's been charged and they go through the EEI, so they're not even going to the children's hearing?
Yeah, that wouldn't come up at all.
It wouldn't come up at all. So anyone through EEI has been charged, it will not go on their criminal record.
Sorry, there is an exception to that. It could come up as other relevant information if not so much that there's been EEI, but if there is something in knowing about that, in going through that process that has given the police intelligence that is then a factor. But it's more about the information rather than the EEI process, if you see what I mean. But yeah, that's the caveat.
Okay, Julianne, hopefully that's answered that. Okay, I'm going to hand you over to Stephen and David now, and then there'll be time for more questions at the end. Thank you. Stuart, sorry. Stuart.
Thanks, Fiona. Good morning, everyone. I do hope you can see my presentation okay and you can hear me okay. I know there have been a few issues with the functionality this morning, so if there's been questions popped in the chat that I maybe have been able to answer, David and I have had a bit of issue with seeing what's been posted in there, so I do apologise for that. So first thing, really, just a quick introduction from myself. It's Stuart Rafferty, one of the Customer Engagement Managers at Disclosure Scotland. I'm joined this morning by David Smith, who manages the team in Disclosure Scotland who are now dealing with the application for review or make application for review team and reviewing the information that individuals can ask for us to consider before it's put out on the disclosure certificate. So it's really the make application review process that I'm going to speak to you about this morning. What that means, how you can access it, what happens when an application comes to Disclosure Scotland, and how we inform anyone that may be able to ask for information to be looked at before it's actually disclosed on a certificate result. And thank you to Claire as well for our presentation there in relation to what goes into the disclosure process. I think the first thing really to say is we come in at the end of this whole criminal justice system. The police are involved, courts are involved, all of those things happen, convictions are handed out, convictions are determined, all of that stuff will happen prior to applications being made to us. And we have to abide by what the legislation and the law says that we have to disclose or what we have to ask people to consider whether or not they want reviewed before we disclose it. So that happens for every application that comes in. And as Claire said in our presentation there, it depends on the level of disclosure and the role that you're applying for and the job you're applying for, what information will be considered, and the age of the individual when they were convicted, as well as the offence and the conviction and the disposal or the sentence that's imposed. All of that stuff goes into the mix. But anything that we supply to an individual on the back of an application, you can guarantee that that information is correct, because we've looked at it and we've made those decisions that that information will either be disclosed because it must be, or it can be asked to be reviewed before we disclose it. But anything that we're going to put out in a certificate will be disclosed unless the opportunity to review is taken up, and then we make a decision. On the back of that, we might disclose it anyway, depending on what consideration processes that are going in, and that's where David's team comes in. And there are rules that we follow that are clearly laid out and have been agreed by Parliament as what we'll follow. So this isn't just something that one person at Disclosure Scotland will take a decision on. There are clear rules that we must follow in relation to making any decisions about disclosing information. And there are also two things I think that's important when it comes to the level 2 disclosures that Claire mentioned. These things are very different in relation to level 2 and level 2 with barred lists, and also for PVG. So PVG is about regulated roles in Scotland and working with children and protected adults. The other stuff in relation to level 2 is for other roles. And depending on which level of disclosure you're applying for, you may have the same conviction disclosed on different levels, depending on what you're applying for. So the decisions are taken on the role that you're applying for in relation to the level, but also the workforce. So children and protected adults. In relation to PVG, if you're applying for children and or protected adults, you might have to go through the process again. But also convictions that come up can lead to individuals being considered for listing, and that's a totally different section of the Disclosure Scotland deal with. It's a total different process in relation to this. So you may be considered for listing, you may be listed, but you still may have other levels of disclosure you can apply for, where the same conviction that led to your listing decision can still be considered. So there's a few things in there. But from the point of view of making an application for review, Disclosure Scotland will take steps to make sure that applicants are informed when that is necessary and when it can be something that they can get involved in should they choose to do that. So I'm just going to talk you through a few things. Hopefully Fiona or one of our colleagues has managed to pop a piece of guidance into the chat for you. So I'm just going to stop sharing my little presentation there, and I'll take you to the web page. So hopefully you can see this. This is a web page for review application guidance. When you click on the review application, it will open up a little Word document like this. And basically, pretty straightforward summary of what Claire presented and what levels it means, and then what will happen when you get to be offered the opportunity to review information. And it's clearly laid out in here. So that's the guidance. You can use that and you can share that with anybody that needs it. And as I say, the actual guidance is there for people to use. So as Claire mentioned, the Disclosure Scotland Act of 2020 came into was implemented on the 1st of April 2025. It's called the Disclosure Scotland Act of 2020 as it passed into law in July of 2020. It is an amendment to the Protection of Vulnerable Groups Scotland Act of 2007, which is, as we commonly know it, the PVG Act, and it makes some changes to that Act. One of the key things is it allows individuals to take more control over the information that Disclosure Scotland will disclose to someone who's looking to recruit that person, whether it's into employment or volunteering or education. It gives people more control over that information. So basically, what happens now from the 1st of April is that anyone who makes an application for a level 2 disclosure has the right to decide whether they share that with the individuals who are asking them to apply for it. And that happens for all level 2 disclosures. That was not something that was there before. So before a counter-signatory or an organisation who's asked you to apply for PVG gets to see the information that we're providing, individuals must agree to share that and consent to share that. And basically on their Scott account that they'll do the applications through, there is that functionality for them to do that. If they don't do that, the counter-signatories and the organisation who have asked you to make the application won't get that information. So that's incredibly important. The application for review process was always there. It was called something different. It was a sheriff court process. And basically, the convictions that Claire highlighted in relation to List B, where it was convictions that were subject to disclosure, subject to rules, individuals were asked to consider whether they wanted to go down the sheriff court route to challenge those. And that meant they had to go to court and do a summary application and provide information and evidence to the court for that to happen. And that was a fairly lengthy, costly experience for individuals because they had to do that themselves. If they chose to have a lawyer involved, that was entirely up to them, but they would need to fund that themselves, and it would take up to 6 months and potentially longer for that process to happen. Since the 1st of April, we've brought that whole process in-house, and we will do that. You've no requirement anymore to apply to the sheriff to have information reviewed. You can do that yourself. So it simplifies the disclosure process, and it gives individuals more choice over whether they want to decide to review any information before it's disclosed. This little slide here just gives you that sort of review there, simplifying the disclosure products and individualises the approach to disclosure, in particular around childhood convictions. So Claire again talked you through what childhood convictions were in relation to the process, and David will keep me absolutely right here because he's steeped in this. Any childhood information we'll make decisions on before it's disclosed. You don't even need to make an application for that to be reviewed. We'll take those decisions first. Now, there will be stuff that we will have to go through the process of asking people to look at, because there are things that we will have to disclose or we will consider disclosing, and there is a process there. So you will be notified if that is the case. But for most people with childhood convictions and childhood information, we'll take the decisions first. So a lot of that will not be disclosed at all. We will take that away straight away. Anyone add there, David?
Yep. Any cases that are currently going through the system at the moment, any childhood convictions, they will be looked at beforehand. So the individual won't be aware that it's being looked at, and whether we include, exclude, more than likely most of them are excluded, and then they're issued without us having to sort of do additional work for the case. So
yeah, I think that's a really it's a really key thing for you if you're supporting people, you know, whether they're children or young people or adults or anybody really, you know, and Claire alluded to this as well. Understanding what might get disclosed is really important. I mean, we heard from the contributor there on the video, you know, they were disclosing stuff at an interview. I mean, why would you be asking somebody to speak about their convictions at an interview? I think that's just ridiculous practice by employers to even do that. You know, we won't, if we decide not to disclose something, then employers are not allowed. They're not legally entitled to know that information. So they can not ask people to disclose that. They shouldn't be doing that. They shouldn't be asking people to self-disclose stuff that we will not tell them about. It's not lawful for them to do that. And people will just tell somebody everything when they're looking to get a job, they're looking to get an opportunity, particularly if they're coming through the experiences that we heard from there, where they're getting back on their feet. And there's the knockback again, the knockdown again. I'm trying my hardest, but I'm still getting that withdrawn. That might be getting withdrawn on the back of something that we will never tell anybody, just because somebody finds it out. But also, employers, when they sign up to get disclosure information from us, are agreeing to a code of practice that says that they will use the information fairly. So they need to consider what that information that we provide to them, whether it's conviction or other relevant information or whatever, is it actually relevant at all to what they've been asked to do for you? And in a lot of cases, that's totally irrelevant. Convictions don't mean that people can't get jobs, can't be employed. And very often, information that we provide has got absolutely nothing to do with the job somebody's been asked to do. So, You know, it's a real balancing act. And I think, you know, from understanding before you even go and apply for a job, if you've got stuff that can be disclosed or might not be disclosed, to really understand what that means for you. On the back of that, if we must disclose it, or we give you the opportunity to say you can review this before we must disclose it, you need to think what that implication is, because there is a process there and it's going to delay the result. As I said earlier on, sharing that information with an employer, we're going to have to take a bit of time to decide on that. Now, that's not months and months and months. It's a couple of weeks at most, I would say, David. And about 28 days is the process time.
Yeah, we allow up to 28 days to ensure that people, you know, if we need more information from them, just to verify, because again, you want to get people back into the workplace, get people, you know, to put across, you know, good representations to say, well, this was the circumstances, this was the background, this is what led to this. So at least I've got a good solid case and a good argument there. So we can apply, obviously, that it's proportionate. Is it relative to the job? So it gives us good information there to help them sort of move on from any offending that may have went on previously.
As I said, it takes away the need to apply to a sheriff. We've also appointed an independent reviewer. Now, the independent reviewer was appointed when we brought in the age of criminal responsibility. So the independent reviewer has been around for a while in relation to childhood information and reviewing that stuff. But that independent reviewer is now there where if we decide to disclose something and an applicant disagrees with that, they have the right in the course to go to the independent reviewer to ask for the decision that we've taken to be looked at again. And that can be, again, quite a straightforward process for them to do. They just notify us of that and we put it into the hands of the independent reviewer. Again, there'll be a delay until the decision is made by the independent reviewer. And you need to consider, you know, what's the impact on me of getting the opportunity I'm applying for? Do I want to continue with that or not? But again, it gives more control to individuals to decide how they treat their information before they put it out to anyone who's looking to employ them to see and make decisions on. You know, it's really given individuals the right to say, you don't need to see this, you don't need to make a decision on this, you don't need to judge me on something that happened in my past when I was a child or whatever. You know what I mean? It's really important that we get this right. As I say, you must confirm that you're happy for the result to be shared with the organisation. So everyone who makes an application for level 2 disclosure must do that. They must agree. They must take the action to do the sharing of that information. And that's done through the Scott account and its functionality that's there. It's quite straightforward. Click on the button and we will then release the information. If you don't want to do that and you want to take the opportunity, because you will be notified by Disclosure Scotland that there is something when you get the result on your Scott account, there is something here that you can ask for us to look at, and it will explain to you how you go about through that process. It gives you the opportunity to explain the context behind the conviction, what happened, why you believe it shouldn't be disclosed, why it's not relevant to the thing you're applying for. And again, if we disagree with that and we decide that it's relevant to be disclosed to an employer, then you have the right to go to an independent reviewer for that decision to be reviewed again. As I say, at the time of issuing your disclosure result, we will explain what convictions can and which convictions can't be challenged. And we'll lay that out. And you've got a choice. You can ask for everything that can be challenged to be looked at. You could decide which ones are relevant that you think want to be challenged. It doesn't have to be everything. So if you've got 3 or 4 convictions, the 3 and 4 convictions could be something that we could look at and decide not to disclose, but you may choose just to tell us, well, we want this one looked at. I don't mind about the others being disclosed. It's entirely up to the individual to make those decisions. And as I said earlier, childhood convictions, we'll deal with that internally, and David's reiterated that. So really that's the process. Now, it's been in place for 3 or 4 weeks now. I'm pretty sure David will be able to explain a wee bit more about how that's been sort of picked up by people. I know that there's been applications made. I know that people have been asking us to review information. I'm not sure exactly how that's been going. Maybe David can explain a wee bit more about that. But the guidance is there. It's really key that individuals who will make applications for the level 2 disclosures, where this will kick in, can decide what they want to have reviewed by Disclosure Scotland. It is a fairly straightforward process, and it does give more control. So I do have time for questions, I'm guessing, Fiona, if
Yes,
that is
Stuart,
the
thank you
case.
so much.
I'm not sure if there's anything in the chat, but I still can't see it.
Okay, if you want to stop sharing, that'd be good.
Yeah.
David, I suppose for timescales, I know you mentioned the 20 days. So somebody had asked in the chat about timescales just for getting some information back, the subject access, just timescales at the moment. So David, is there any update just in relation to timescales in general?
Unmute.
Oh, David, I can't hear you.
You're on mute.
Apologies for that. I've had to move room.
All right.
No, the time frames are 28 days max that we would do. If somebody's put in a request to make an application for review, it would be a 28-day maximum period. And if there's public holidays in between, then that time will get added on.
So 28 working days.
Yeah.
Okay. That's great. If somebody's asked, Claire Stewart's asked, is there anyone at Disclosure Scotland that would come out and speak to community groups to answer questions about all this? Are you doing that?
We run, the customer engagement guys run, we're going to be running webinars on this very subject. So we've got a 2-hour webinar that we're going to be running. If anybody's interested in it, you've got my email address, Fiona. Happy for you to share that, and people can drop me a note to say that they're interested, and we can make sure that they are included once we publish the webinar. So the webinar's a 2-hour webinar. It goes into more detail than I have this morning in relation to the process and, you know, what you do with the information and all the stuff around that. So a lot of what Claire was speaking about earlier, we're including that as well to give you a bit of background, you know, from subject access. This printout that you get from the police, because it's just a big screed of stuff. And what do you do with that? How do you know that that's relevant? How do you put that into context? What age was I? When did it happen? What was the conviction? What court did I go? All that stuff is all factored in there. So, you know, we will help people understand a wee bit more about that. So yes, we have that opportunity that's coming. So it's not there just yet, but we will be publishing it going forward. So it's a good idea maybe to come on that, and then, you know, we can speak to groups individually as well. Yeah.
Okay, Stuart, thank you. Sally, could you maybe put Stuart's email address in the chat? I see somebody with their hand up, but I think
Richard
Mike's
Thompson.
I don't know if that function's available for people or if they need to put it in the chat. Let me double check, but Kelly's put one. I work quite often with 16 and 17-year-olds who have been accused of sexual offences and varying seriousness. I assess for diversion and then work with the young people if diversion is approved. So sexual offences to diversion from prosecution. These would be enhanced diversions. Would this impact PVG? And
Yes.
also domestic abuse offences through diversion.
As I say, it comes as us as a conviction, or it comes to us as other relevant information, we have to look at that. So if it's a PVG application, what we're looking at there is something more than it would be for a level 2 or a level 2 with bad list check. So we need to look at whether there's any information that places somebody under consideration for listing, or they're a risk to working with children and protected adults in a regulated role. So the PVG considerations about information is different from the other levels of disclosure that people might apply for. So it's key to know when you're making applications for anything that involves regulated roles, so that's university courses, college courses, employment, volunteering, anything that brings you into the PVG scheme sort of environment, you need to be aware that we will look at these convictions, and it could lead for individuals to being considered for listing or even listed, because if there's serious convictions there around a sexual nature with children, for example, the likelihood is that that will lead to a consideration for listing and possibly listing. I won't say it will lead to listing because a lot of considerations around that, but it can do. And that would be before an offer of employment would be made, because organisations can't offer employment for people to get into a regulated role without first seeing a disclosure check, without seeing the result of that information. Because we can say to somebody that they're under consideration for listing, but you can still do a regulated role. We would consider with the consideration process, which might lead to consideration, therefore they can't do a regulated role. If there's something very seriously there, and particularly around sexual offences against children and things like that, they are very often automatic listings for individuals to do regulated work. So it's really important that people know before they apply for these things what the impact can be.
I suppose, I think one of the questions that have come up, and it's maybe a bit here, I'm trying to understand what you're saying, but in a bit of a contradiction, because obviously a decision's been made not to prosecute, decision's been made that the individual can, or the child in these instances, can go through diversion from prosecution. They're successfully completing the diversion from prosecution, but their Disclosure Scotland are, help me if this is right, Kelly, but Disclosure Scotland are considering them for the barred list and asking them to make representation. So the PFs thought it's not in the public interest to prosecute, so they went to diversion, successfully completed, but you're looking at a barred list. How do the individuals who have successfully deal with that? Because that's quite a contradiction, because they've not been prosecuted through court.
It's not about prosecution. It's not. Considerations about listing are about behaviours, and it's not just about criminal convictions. So, the police will decide if there's information that's not convictional information that's relevant when an application's made for PVG. So they'll decide that there's potentially other relevant information that they need to make us aware of. Sorry, David, you were going to put something.
No, exactly as you say, you would look into the factors. The police will probably hold ORI on it. They would disclose the ORI. Then it would come to us. It would then obviously be looked at by our protection services. They'll be looking at that as well. You'll be risk assessing as well. What is the content? You'll be getting more background as to what were the circumstances, how did this happen, and looking at, is it proportionate to how the job that they're actually doing? Is it proportionate that the individual should be considered for listing? What information do we hold? So you would be doing a whole risk assessment just to ensure that the safeguarding element has been met and that it's fair as well.
That would only be a consideration if it's a PVG application, and it's relevant to the workforce the person's applying for, because if it's not relevant to adults, then we won't get that information or consider it.
Okay. And you'll look at, obviously, requests for information from professionals involved, and like the young person who spoke,
yes,
references and things. Okay.
Yeah.
Somebody had their hand up. We can't access that. And if you can put your question in the chat, if there's an issue, please email cycg@strath and we'll put the question on for you. But Claire, can I bring you in? Christina's asked about images, and if images are always going to be in the disclosed.
Yeah, the sharing of intimate
indecent images.
Indecent images, that's the offence. So it depends. There's a range of offences that are related to this kind of behaviour. So the specific ones are listed then on list A. And if you follow the links in the presentation, you can then figure that out. But yes, that offence specifically is on list A, so it would always be on list A. It's based on the offence. There's no nuance to it in this kind of context. However, the nuance bit is it can always be disclosed. Whether it will is then where the decision making comes into play, if you see what I mean. So it is definitely on list A, so that offence, so it would be considered. and it always can be disclosed, but Disclosure Scotland will take a decision about whether it should, in the circumstances, be disclosed. So I hope that's kind of clear. If you follow the links in the presentation, it gives you the specific offence types and whether they're on list A or list B, and it is the specific offence that is the thing. So figuring that out. And those lists are really helpful. There is the lists that I've linked to draw from legislation, but that's even more complicated because it then says section 52 of the criminal procedure or whatever it is, and then you have to figure it out. Those lists just give you the offences, so it is the best way to get that information.
And then if anyone is still unsure, at the end of Claire's presentation, you've got the contact details, so you can contact CLAN or CYCG or Disclosure Scotland themselves.
But the list information is in the guidance that I shared as well. Sorry, Claire.
Yes, and that's been shared on the chat, Stuart. Yeah, sorry, Claire, come in.
I was just going to say, Debbie's just saying, but those lists only apply if it's a conviction. Yes, that only applies for relevant spent convictions when we're talking about list A or list B. If you're in doubt, go back to that diagram. It is there, but it'll just take you a few readings to get it kind of in your head. And obviously come and chat if you're still confused.
Yeah.
And just one thing before you can, sorry, Fiona, there's one thing that's maybe important that I didn't mention before, is that if we decide not to disclose something, it doesn't mean it's been removed from somebody's criminal record. It's still there. It's only the purposes of disclosure that we're making decisions on. So it's not expunged from your criminal record, that it will always be on your record. So that's when we're saying when you get a subject to access, there could be lots of stuff on there and lots of stuff that's not relevant, you know, so.
Yeah, and Cass, I ask a question, so which I think we've maybe answered earlier, though I'm still unsure how you'd maybe know if someone's got a social worker. So how do Disclosure Scotland gather information to make a decision? Will you contact social work for a discussion about risk assessment? But how do you know if the child's got a social worker?
We would be able to see by the conviction type. So by the conviction type, obviously, if it's somebody who's offended and they're maybe more mature as we go on, there probably will be no information to go on. So, and again, we need to assess it in terms of time frame. How long is there a period of desistance from offending as well? So again, your risk assessing. If we would generally just contact either the courts, or if it's a children's hearing, we would just make an inquiry, see if they've got any information. If they come back and say they don't hold any information, then we would generally not disclose, because you don't have any information to back up as evidence there. So we would seek out where possible.
When the individual's been asked to make representation for their make application to review, if they want to do that, you know, they're given the opportunity to provide anyone who will substantiate their representations, or even help and support them to provide that. So we would come to know that there's somebody there, a social worker or a support worker or whoever's there to help and support people through that process. And it's absolutely fine for them to do that and to get people to, you know, provide representations on their behalf and to support their representation. So that can often be the most key thing as well, is to get that context from other people about, you know, what folk have been doing since that conviction happened, and, you know, what they've been volunteering and all the things that have been going on in their life since.
Yeah.
So the young person themselves can suggest their social worker. I know, Kath, I know with a young person, I know I've written a reference, their social worker wrote a reference, and a police inspector, I think. So I think they can select whoever's
George McDonald, please contact reception.
Sorry.
No, you're fine. Maybe make that reference. So Jane Kelly has asked, will there be anonymised updates on how or whether discretion is being used, so we know practice is defensible rather than defensive? Good question.
I mean, I wonder if it's helpful just to explain the role of the independent reviewer. You're probably better placed than me, Disclosure Scotland, to explain that bit, but that gives some reassurance, I think, Jane.
Yeah, I think with the decisions that we make, obviously we need to make sure that we have done the background work, what evidence that we have to make those decisions. Have we followed what is in the legislation? Have we followed, what the individual has provided us with? What evidence is there? So we then need to collate a case where if the individual disagreed with what our final decision is, then the independent reviewer would make a request to Disclosure Scotland for all the information what we've based it on, and then we would share that with the independent reviewer. And the independent reviewer, once they've done their findings, they would just feed back to ourselves what they have decided and why. So it could be, sorry.
No, sorry, David, I'm sorry to interrupt you. Go ahead.
No, it's just that, there's some lessons that can be learned from what we get back from the independent reviewer as well. So far, we haven't had anything that has went so far, but it's still early days just now, so.
That's what I was going to ask. Will you be collating that information? Somebody said it'd be good to come back after a year and see how the discretion aspect's working, but I'm wondering, will you be collating and publishing any information about the number of requests and times, decisions have been changed and the reasons?
We probably would not provide reasons. We would probably maybe provide the volumes of cases for people who have requested review and how many have been removed and how many have not. So
is that something you'll publish?
I have no idea. That will be, we'll speak to our corporate governance people and see what they think. I do know we are collating as much information as possible, because obviously there is quite an interest in this. And also the types of convictions as well. We're keeping a record of that. If it's, a violent offence, sexual offence, anything at all. So we're keeping a note of that so we can assess, right, is it driving offences, such like, so that we've got information there that we can share as much as. And again, you'll get press inquiries as well.
And you could potentially FOIs. I think it'd be good, I suppose somebody's putting there, it'd be useful in building trust in the process if you could be transparent and publish that data as much as you can. I suppose maybe a request to your governance if that could be something you consider doing.
I think it probably will be.
Okay. David. Correct me if I'm wrong here, David, but we have published our framework for making decisions. The decision-making framework is called that. It's on our website, so that's a public resource for people to look at, and it'll lay out, how we treat their information, what we'll do with it, how we assess it, and all that. So that's all out there for people to use and look at. So
and that's again with our decision-making framework, we need to be as transparent as possible. So. If anybody challenge whatever decisions, then we have to give an explanation why we have made that decision.
Yeah. I've got a question emailed to me. So Richard, hopefully I'm getting this right, the chat function's not available to him. So my question related to net widening for the scope of regulated work. So it's really important that people can have pathways through volunteering and employment. So if employers are comfortable about safety, managing a barred person in a particular job, how can they sort of reshape that job so it's not defined as regulated work?
Well,
that makes sense.
Basically, if it meets the criteria that's laid out as a legal requirement for a regulated role for somebody to be in the PVG scheme to do that, so it's not lawful for somebody to carry out the duties of a regulated role without being a PVG scheme member, and it's not lawful under the legislation for anybody who has been barred or listed to apply to do a regulated role for the group or workforce, so children and protected adults for whom they have been listed. So if I was listed for work with children and I made an application to volunteer for a local football team, to coach kids, I'm breaking the law by even approaching that that club to make that application. So that's not lawful to do that. And it's not lawful for an organisation to consider somebody for a regulated role and knowing that that person's listed. So if Disclosure Scotland, informing an organisation in the back of an application, you can't employ this person because they're barred, and they decide not to take that advice and just employ them anyway, they're breaking the law basically. So they will be reported to Police Scotland for that. So no, it's not possible to to sort of bend the rules, if you like, in relation to what the legislation says around people who are listed. When the consideration process is happening, the vast majority of people who go through consideration for listing don't get listed, because, we're not here to stop folk working. We're here to provide a service to make sure that children and protected adults are kept safe in the services that they're seeking to use. And it's right that we stop people who are at risk, not just because they've got a conviction, but because they're careless in what they do. They just go around doing things inappropriately. They place people at risk of harm because of their behaviours. There's a lot of things that we consider. And, it comes back to what happened in Sohama way back in 2002, and what happened there, that individual was able to get access to those kids. They hadn't been stopped from various things that a person had been doing over the years, and that wasn't all about convictions, that was about his behaviours. So it's really important that aspect of this remains in place. So if you're under consideration for listing, you can do a regulated role. You're not barred, so you can continue to do that. And it's very good practice for people as well who are looking to employ somebody or even have somebody in their employment who comes under consideration for listing, is to help them with the representation so that we decide the right thing. If they're able to continue doing a regulated role and we won't list them, they can continue doing that after we make a decision not to list. We've taken that decision. So it's really important that we don't just have organisations making knee-jerk reactions to sack folk when they come under consideration for listing, because very often we will not decide to list. And we've got powers that are coming in later in the year to help organisations to put things in place. So maybe this is what was being asked here in relation to that around consideration for listing, is we will put measures in place that say, these conditions, if we impose these conditions, this person can remain in an employment.
Just frozen right at the last second there, David.
Yes.
Yep. You just froze there. No, that's
sorry.
fine.
The other thing around regulated work is that if you're barred from doing a regulated role, it doesn't mean you can't work as a gardener or a truck driver, as long as there's no regulated role involvement in that work. It's not stopping people from seeking other avenues of employment. So.
Okay, thank you. Hopefully that answered that, Richard, for you. So I'm conscious of time. We've got 2 minutes left. Just anyone in the panel, Claire, David, Stuart, any final words you want to say before we finish today?
Can I just quickly flag up one thing, which is about information and how long it's kept? So just to make people aware that the Children's Hearing System don't keep information after someone turns 18, where social work keep records usually for 100 years, few exceptions to that. But it's just potentially important for information to be in those different places and to be thinking about that in terms of then the review process. So just thought I'd flag that as a consideration.
Yeah, that's a good point. So if SCRE say they don't have any information anymore, it might be that social work does, and they could help with your decision making.
Yeah.
Yep. Thank you. Thank you to everyone for joining us today. I really enjoyed that, and I've learned so much. I think working with children and young people for the past, 30 years, disclosure's always been something that I've never quite got my head around, and I'm not saying that I'm quite there yet, but I definitely feel more informed after today. So thank you all so much. Sally's just posted on there if you would like to, if you've not already, sign up for the CYCJ e-bulletin and future webinars. I think the next one's actually on Friday in relation to antisocial behaviour. So I would just like to take the opportunity, so Stuart, David and Claire, to thank you all so much for taking the time to be with us today, and thank you everyone who's joined us today for joining. Thank you.